Good morning, Ms. Warren. Good morning, Mr. Roth.
Good morning, Your Honor.
All right. Ms. Orange, I don't have a notice of appearance for you, but are you on the Elidor case?
I am, Your Honor. I filed it yesterday afternoon. It was like 3:40. I filed the driver's license, the notice of confidential filing, the notice of social security number, the notice of related cases, the affidavit of military service, and my notice of appearance and email designation. Those were simpler for my staff to file while in my absence. So I'm meeting with Ms. Eliador so that I could provide a substantive, responsive pleading. In addition to the answer being outstanding, the financial affidavit and mandatory disclosures would also be the only items remaining. I do notice that the husband has not yet filed a financial affidavit or any forms of mandatory disclosures.
Okay. Mr. Roth, we're here today on your motion for a court default.
Yes, Your Honor.
Given Mrs. Orange's appearance, what's your suggestion on how to proceed today?
I submitted to Your Honor a proposed order which actually basically allowed the wife to have 10 days. I filed this a couple of days ago, not expecting the court to grant the default immediately, but to allow an additional 10 days. I would only say that, when I first went into this file weeks ago, Ms. Orange had already entered her name into the system. So I don't know why they've needed, 40 something days. These parties own a house and they're living in it, and we're missing a huge opportunity to get it sold. But obviously I have no objection to 10 days for them to file this very simple response.
I do. Less than 10 days. Can you get an answer on file by Friday, Ms. Orange?
That's fine, Your Honor. And just to piggyback off of what Mr. Ross said, the wife initially consulted with me and was on a waiting list for legal aid. So okay. I did file her motion for extension of time. That's why my information is in the e-filing portal. At that time, she had not retained me. She has still not gotten back to her from legal aid. So it's not a matter of my information was in the court file ahead of time. She retained me yesterday. So that's why you didn't get anything from me until yesterday.
Okay. So here's what we're going to do for today. Ms. Orange, you'll have to close business Friday to file an answer.
Okay.
If you don't file an answer, then Mr. Roth, please prepare and submit the order on a court default. And I would enter that on Monday.
Yes, sir.
Do you have any questions regarding the court's order, Ms. Orange?
Well, Your Honor, even if this was in a position for default, the husband would still need to file a financial affidavit as well as certificate of compliance or disclosure. Is there any way we could perhaps put in the order that the parties need to schedule mediation within X amount of days?
Only if right now that's not before the court, but it seems like it's a very fair thing that you all could agree on if we're doing a case management. Mr. Roth, is any reason you can't mediate this within 30 days?
No, I would support that, Your Honor.
Okay. Mr. Roth, would you mind preparing the order in this matter?
I will revise the proposed order I submitted to Your Honor a couple days ago.
Okay, and parties will go to mediation within 30 days?
Yes, sir.
And Mr. Roth, what's the status of the financial affidavit? Or your?
I'm pretty certain that it's complete. We just didn't serve it yet until we were getting past this issue.
Is there any reason we can't put in the order that you'll have it on file within 2 weeks?
That would be fine. Both parties are going to submit their financial affidavits within 2 weeks.
I would like to say that.
Disclosures, not just the affidavits, if we're going to go to mediation.
I'm sorry, what, Ms. Orange? Are you?
All mandatory disclosures, not just the financial affidavit, if our goal is to go to mediation within the next 30 days.
Can we do it in 2 weeks?
That's fine. Absolutely.
Okay.
Let me also, I know we only have a few moments here real quick. I think I need to move it to the mediation to be done by at least the end of July. I have a 2-week vacation where I'll be gone for half of July, the first half of July. So if we would agree to have the mediation by the conclusion of July, that will make it, I'll be certainly, it'll be easy for me to accomplish that.
Okay, so what we'll say in the order is on or before, and I don't know, is it July 30th? Is that the last day of July?
I think it's 31, but
July 30th. So it'll be, the mediation will occur on or before July 31st, 2021 in the order.
very well.
Yeah, Your Honor, we could put in the order that the parties shall schedule mediation within 10 to 15 days and mediation to occur within 45 days. That's about where we're at.
Okay, but let's just keep it where it is, because
Okay.
that way you're mediating before July 31st anyway.
That'd be great. That'd be great.
Okay. Is there anything else the court can do to help this case along?
That's it.
No, Your Honor.
Okay. All right.
Yep.
Have
Great.
a great day. Bye.
Thank you very much. Appreciate it. Good morning, Ms. Orange.
Good morning. Have a good day.
You too. Bye-bye.
Thank you, Your Honor.
Bye, Ms. Orange.
Morning. Good morning.
Good morning. Hold on. Let's make sure everyone's here. All right. Good morning, everybody. We're here on the case of Hernandez and De La Cruz versus Pena.
Yes, Your Honor.
19 DR 2330. Please enter your appearances.
Yes, Your Honor. John Gilhart on behalf of the petitioner Francisca De La Cruz.
Ling Cal on behalf of respondent biological mother Alma Pena.
Okay. All right. Thank you. So we're here today on the petitioner's motion. Basically, it's for appointment of guardian ad litem and for, I guess, drug testing and evaluation of the mother. Is there anything else that we're here today on, or is that it?
Yes, Your Honor. We're also here on the biological mother's motion to terminate temporary custody.
Biological father's motion?
Mothers, respondents.
Okay. The supplemental petition?
Your Honor, we filed a verified motion to terminate Chapter 751, temporary custody order.
It was filed on April 5th, Your Honor.
Yes, Your Honor.
Okay. Got it.
Thank you.
All right. Before we begin, has there been any discussion between the parties, or are we at an impasse?
There's been no discussion, and I don't think there's any need to do one. They're very adverse to each other. The positions are totally opposite in this case.
That's very sad.
Yes.
Okay. Trying to figure out how the best way to do this is, because obviously if I appoint a guardian, then we won't be terminating today.
Well, Your Honor, if I may address her motion briefly.
Yeah.
I filed a memorandum yesterday, and just in all disclosure, I filed it yesterday, so as not to telegraph my argument, because essentially opposing counsel has filed a motion to terminate the temporary custody order, and that's just improper under the Florida procedures and the statute. The statute requires you to file a supplemental petition and serve it upon the petitioner in her case. And that would provide my client 20 days to answer, admit, or deny the allegations. We could do discovery. I'd move to appoint a guardian ad litem in that case as well. But the point being, a motion's not proper unless this was a concurrent custody issue. That is in, I think, number 6 of 751, the statute that's referenced. But, or sorry, 7. But in our case, it plainly requires a petition. And if you look at, let me pull up my memorandum. If you even look at the family law rules in 12.110H, it requires all supplemental or all subsequent pleadings to a final judgment subsequent to final judgment must be designated as supplemental petitions, and the action must then proceed in same manner and time as though the supplemental petition were an initial pleading.
Okay. Did you send your brief to?
I filed it in the court record, so it was served.
I received it, Your Honor.
I did. The problem is the judge doesn't have it.
Oh.
So what I'd like for you to do is, can you email it now to my JA?
Yes, I can.
So I can review it and become familiar with it?
Yes, Your Honor.
And without me having reviewed it yet, Ms. Kao, what is your position regarding that procedural issue?
Thank you, Your Honor. I am aware of opposing counsel's memorandum of law. I received it yesterday, and I would like to ask Your Honor that today please hear our motion to terminate on a temporary basis and enter into an order of suspend time sharing on a temporary basis and allow us to cure the procedural issue or defect.
So it sounds like you agree that there's a procedural issue?
Not really. I mean, that goes to my second point in my position, and I believe we're asking for a termination, not a modification. So the family law rules of procedure doesn't really apply in this case. And I am aware of the Chapter 751 statutes. And in essence, in this case, what the parties have in reality is a concurrent child custody arrangement. My client has her place and has the child from Mondays to Friday. And I
got
believe
that, but that's not what the order says.
Okay, I understand that. Yes, I agree.
Okay. I'm sorry, I didn't mean to interrupt you.
No, I understand, Your Honor.
I'm sorry, Your Honor. Who's your judicial assistant?
Cheyenne Phillips.
Cheyenne, okay. Cheyenne Phillips, okay.
So do the parties have a written parenting plan? I know what they've been doing in practice, but is it written?
There is one.
Yes, there is one.
With the court. But that does not make this a concurrent. I mean, a concurrent specifically provides for that a motion may be filed, but this is a temporary custody order. The order specifically says my client has temporary custody of the child. Yes, there's a parenting plan, but that's because this was agreed to, so they worked that out and attached that as well.
Okay.
And I just sent that, Your Honor.
Ms. Kao, can you continue at least with your procedural argument? I'm gonna, just so you know, I'm gonna take a break after this so I can review the motion. And
yes, Your Honor. Yes, I mean, my third argument would be this case is pretty clear that the memorandum and the issues were brought up for delay, for purpose of delay without making accusations. My client has been continuously dragged to court for contempt hearings, for a supplemental petition for modification, and here we are on the motion to appoint guardian ad litem. It is a custody case between a biological mother and a third party. So, I mean, the court has been consistently applied parental referential in this kind of cases.
okay. So she has been brought up on contempt, but
Yes.
it's also been granted.
I understand. And then since the contempt hearing, my client has been complying with the parenting plan on file.
Okay. All right. What I'd like to do is just take a couple moments to review the case law before we get into anything else. So I'm just going to go off screen for a little bit, and I'll hopefully be back within 10 minutes.
Thank you.
Your Honor.
Our time. We're waiting. Just one more waiting.
This time is like
Ms. Cow, I think I can still hear you.
Oh, thank you for letting me know.
Yeah, no problem.
Okay. Let's see.
Mr. Gilhart, has it been sent yet?
Yes, Your Honor, I just emailed it. Hang on, let me double check to make sure it went through. Cheyenne Phillips, right? C. Phillips at CA, CJS. Yeah, we see attached memorandum of law. It went through only 2 minutes ago, though.
It's still not coming through. Mr. Gilhart, make sure you're not sending it to her ex-DCF account.
I have, let's see, ca.cjis20.org. That's what I have.
Does that have 2 L's for Phillips?
Let's see. Yeah, C. Phillips, PHILLIPS at ca.cjis20.org.
Okay.
Forward it again. Hang on. I also think I asked my paralegal to email it. See if she emailed it too. Oh yeah, Jenna sent it. Jenna sent it yesterday at 12:30, and Cheyenne said she received it around 12:44. Judge Cohen. Oh, I'm talking to nobody. I don't know if he's there. When I open my email, it blocks off the whole Zoom.
Yeah, we got it.
Okay, thank you, Your Honor.
Gilhart, I reviewed your motion, a couple of questions, and also, I guess, comments, where I reviewed your memorandum. First of all, do you have any authority that this is a final judgment? This
Well,
is
other
just
than
a
the-
temporary order.
It's a final order.
Where do you,
I mean, it says, I mean, in the statute, I don't know that it needs to necessarily say exactly final judgment. Where did I just put it? Just put it. Oh. I mean, the statute specifically states under 75106, the parents may petition to terminate an order granting temporary custody.
it does say that, but in the actual order itself, it says the mother and the father of the minor child shall file a motion with this court to modify or terminate this order if he or she desires to obtain court order visitation or legal custody of the minor child. So that order specifically permitted her to do it by a motion. That's G of the order.
I don't know that the court can order away from what the statute requires.
The statute would speak if there wasn't a court order allowing it. If the court order didn't say how to do it, I would agree with you that a petition would be required. But here we have a court order that specifically says how she would need to do it in order to terminate.
Well, and it doesn't, I mean, it doesn't, or to terminate this order. Yeah, sorry.
So here's what we're gonna do. I'm still gonna have an open mind, Mr. Gilhart.
Yes, Your Honor.
But I'm not convinced that she can't terminate this by motion the way that she's seeking. So here's what we're going to do. We have 120 minutes today. You know, I want to hear what's going on, and I want to especially hear the evidence that you have to support your motion for a guardian ad litem.
Yes, Your Honor.
I think potentially terminating it is in play today, but it doesn't just necessarily mean that that's going to happen. I have to hear evidence about this. So considering right now, I kind of view your motion, Mr. Gilhart, as paramount.
Sure.
Why don't we start off with your motion for guardian ad litem and for what's the other relief is drug testing.
Yes, Your Honor. And just so you're aware, Your Honor, I filed a motion to determine the confidentiality of a couple of my exhibits. I just fully,
Oh yeah.
yeah.
That's obviously going to be granted because I took
Okay.
a look at the exhibits and I was stunned that
Yeah.
that was in the court file. So
Thank you, Your Honor.
if you could submit an order granting the confidentiality of those things.
Thank you, Your Honor. Okay.
Okay.
May I proceed, Your Honor?
Yes. Can you please start off though by giving me a little bit of background on what it is that's occurred that's leading you to seek a guardian ad litem, or what you're going to present as evidence on this?
Yes, Your Honor. So essentially, the child they have been exercising the parenting plan that they agreed to. But now what you'll hear today from multiple witnesses is that there have been, or at least we'll present exhibits and some testimony that present that there's some concerns about ongoing abuse or neglect, at least as defined in Chapter 61. And Chapter 61 references Chapter 39 to demonstrate abuse, abandonment, neglect. So we're essentially, to define what we're looking for, it's under Chapter 39. I mean, it's almost a mini dependency hearing. So there's been a reason to believe that there's some type of at least harm or neglect that's going on, and it continues to go on. And my client is ultimately, she filed her supplemental petition to, she has temporary legal custody, but she's trying to get the child enrolled in some counseling and cannot do that because the parenting plan only permits her to start exercising her time after school on Friday or beginning Friday and through Sunday. So she doesn't have a weekday, and she's having trouble finding a counselor, and I think one is necessary, and I don't know that mom is going to agree, and we would like a guardian ad litem to essentially come in, testify on behalf of the child, and give us a report on what the guardian thinks are the concerns of the case and the need for the counselor, and modify the plan to permit my client at least one day or something that she can, or at least a caveat that she can interrupt the mother's time during the week to take the child to counseling. So that is the ultimate goal, and we like a guardian ad litem to represent the child's best interest today. And under 61-401, the statute of reference to appoint a guardian ad litem, it's typically, if this wasn't a child abuse allegation type case, it would be a discretionary, an abuse of discretion standard of review. But we are under the second part of the appointment under 61-401 that states, in such actions which involved an allegation of child abuse, abandonment, and neglect as defined in 3901, which allegation is verified and determined by the court to be well-founded, which is what we're going to try and demonstrate today, that this is a well-founded allegation, the court shall appoint a guardian ad litem for the child. So I have one case that kind of discusses the appellate review for this prong of it. And that case citation is, it's from the 4th District. It is, CM, the mother versus Department of Children and Families. It's 854 Southern 2nd 777. And essentially, it's reviewed for fundamental error. And this case states that the court must determine whether court's failure to appoint a guardian ad litem absent objection is fundamental error. And this court kind of talks about what is not fundamental error. It doesn't really give me what is, but it does state that in several cases, district courts have determined that it's not fundamental error when a trial court fails to appoint a guardian ad litem where there are no guardian ad litems available because it is something voluntary, or I guess in this case, because it's in a civil matter, whether or not there be some type of payment issue. I spoke with, I put Keith Grossman in my order. He's been very busy, so I called Rebecca Beto, and she has already agreed to take over being the gal in this case, and my client will agree to advance the cost. So
that's Rebecca who?
Rebecca Beto. It's BEDDOW.
Sorry, Mr. Gilhart, I didn't mean to interrupt you. Please proceed.
No problem. And I think even if opposing counsel's motion is proper today, I think appointing the guardian ad litem is necessary as far as discovery concerns. I mean, that's why I argue we need a supplemental petition so I can engage in proper discovery. But the goal today is to appoint a guardian ad litem. There's also some concerns over substance use. To get an appointment of a substance abuse evaluation, it's under 12.360. Needs to demonstrate that there's good cause and the matter is in controversy. Pull that up. I have a case I typically go to. This references the civil rule, but they're analogous. This is 1.360. It's the same rule essentially in 12.360. It's FRUH, F-R-U-H, v. the State of Florida Department of Health and Rehabilitative Services, 430 Southern 2nd 581. And it states that an examination may be ordered when the mental condition of a party is in controversy and good cause is shown for the necessity of the examination. And in controversy means that the party's condition is directly involved in some material element of the cause of action or defense. And good cause means the mental condition of the party, even though in controversy, could not adequately be evidenced without the assistance of expert medical testimony. So I don't know that I'll be able to demonstrate whether or not the respondent has any substance abuse issues that would affect the child in some type of negligent manner without an expert medical testimony. And I think by the very nature of the allegations, this is in controversy. I expect to elicit some testimony to help support that as well.
Okay. Mr. Gilhart, in your view, what would Ms. Kao need to show today for me to terminate the order? What's her burden?
Her burden, well, she would have to demonstrate that she's a fit parent. I don't think I have a case on point for the appellate standard of review.
Is it because the child is in this extended custody arrangement, do we start from the premises that the premise that she's not fit and she has to prove that she is fit?
Your Honor, I don't have that case available, or I don't have the authority available to answer that question.
Okay, I'll look it up. All right, Mr. Gilhart, do you have anything else as it relates to your motion at this time?
No, Your Honor, other than I'd like to start calling witnesses.
Kao,
Oh, well, she has.
briefly, can you please respond to Mr. Gilhart's motion?
Thank you, Your Honor. And in this case, evidence will show that my client has been trying very hard to be a good mother. She doesn't exactly have her life easy. She had a marriage of a nightmare to her, and at the end of the divorce, she was able to, divorce her abusive husband and was awarded sole parental responsibility, full-time sharing with her son after a full trial. And during some difficult time in life, she accepted her mother's help, and until this day, she is still very grateful for her lending her help during, again, those difficult times in life. Since the entry of the order, she consented to the temporary child custody in the hope that she was able to reestablish her life. That's exactly what she did. She gained a full-time employment. I mean, she has a place of her own. Evidence will show that she is trying to be a good mother, and she is capable of doing that. The reason for us to be here today is since she moved out of the mother's house with the child, she was constantly being dragged back in court. As the docket, Your Honor, and you can see it's
Rightfully so, though.
Yeah. Yes. She is actively working on herself to be a good mother. She is fit. You will hear some testimony today, and she is sober, and evidence is clear that she is able and willing and continually to work provide for her son's needs by herself. There's no legally sufficient evidence that you will hear today to establish that she is unfit parent under Chapter 39, I'm sorry. She has never abandoned, abused, or neglected her son. It is also not a case of removing a child from already familiar environment to a new environment. I mean, parties today, they already are exercising this type of arrangement, and the 5-year-old is living with mother in their place. And to answer Your Honor, the question about the standard of review, I have a case on point. If I may give you the case number is Seilkop v. Barker, Seilkop v. Barker. And the citation is, I have a number, is 1 capital D 14-560, and that's what I see on the opinion that I have today. The standard.
That doesn't sound like a cite.
Yeah, but this is what I see on the case that I printed out, but I can send you.
Is that Westlaw or Lexis?
That's Cases and Codes Fine Law. It's decided on October 29th, 2014. I will look it up and send it over to you, Your Honor.
What was the title again?
Yeah, I was going to ask.
Say Seilkop v. Barker. And I'm sure if I look harder.
How do you spell Barker?
Yeah. Should be able to find it. Okay, so Whenever you're ready, Your Honor.
Trying to hunt for the case. All right.
Okay.
148 Southern 3rd, 865.
Thank you.
Okay. What does that case say?
Essentially, as a trial court has no discretion and must grant petitions to terminate temporary custody, even if opposed by a child's current caretaker for good reasons, if a parent is deemed fit. In determining that a parent is unfit, the court must find that the parent has abused, abandoned, or neglected the child as defined in Chapter 39.
Okay.
Yes.
All right, Mr. Gilhart. I'm sorry, Ms. Kale, were you complete?
Yes. Thank you, Your
All
Honor.
right, Mr. Gilhart, please proceed.
Thank you, Your Honor. First, is there anybody sitting in the Zoom lobby?
Mr. Hamish.
Mr. Hamish.
Yeah, I was confused by that as well.
I have a witness. His last name's Martinez. But he wasn't familiar with Zoom and I had to give him instructions. I wonder if he put a wrong name.
Let me see what Mr. Hamish is doing here.
Yeah. Thank you, Your Honor. Oh, Mr. Hamish. That's an attorney.
Yeah.
Yeah, he's not one of our witnesses.
Yeah, but I want to figure out why he's here anyway.
Okay.
I may be in the wrong.
Yeah. Yeah, get out.
I have a 10 o'clock, but I may be in the wrong meeting room.
Yeah, you don't have a 10 o'clock with me, so I think it might be the wrong place.
Okay. Thanks.
Nice desk, though.
Thanks.
All right. Bye, Mr. Hamish.
Bye.
I don't have anybody in the Zoom room other than
Okay.
that, Mr. Hart.
Well, if we
Do you want to take a break and see if you can get them?
Yes, Your Honor. I'll call them right now.
Okay.
And it was my witness that was subpoenaed, so
Which
I might
can
have an issue if he doesn't appear today.
That might be a problem. Okay,
Yeah.
so let's just take, we'll take 5 minutes. It's 9:44 right now. We'll be back at 9:50.
Thank you, Your Honor.
Honor.
Mr. Gilhart, are we?
Your Honor, I wasn't able to get a hold of him. I've texted him. I've called him twice here. I think if I don't have him appear by the end of the hearing, I'm going to need to request an order to show cause. And I can proffer what he would testify at the end of the hearing. It may or may not be necessary. If you don't think you need the testimony, then we can ignore all that. So,
Okay.
I'll call my client, Miss Francisca De La Cruz, first.
All right. Good morning, Ms. De La Cruz. Please raise your right hand to be sworn in by the clerk.
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
I do.
Can you please state your name and date of birth for the record?
Francisca De La Cruz, November 23rd, 1972.
Okay. Thank you. Please proceed, Mr. Gilhart.
All right. Can you hear us both? Okay.
Yeah.
Okay. Thank you. Ms. De La Cruz, who is the respondent, Ms. Alma Pena, in relation to you?
She's my daughter.
And who is Edgar in relation to you and her?
My grandson.
And how old is Edgar currently?
5 going on 6.
And since our last hearing on enforcing the current temporary order, have you and Ms. Pena been following the parenting schedule?
Yes.
And what time do you have with Edgar?
From Friday after school till Monday morning when I drop him off at school.
Okay, and have there been any concerns when you have Edgar in your care?
Yes.
Okay, so let's start with physical concerns only. Can you just generally speaking, what concerns do you have over his physical condition?
He has bruises, scratches, rashes, a lot of things, that I notice in his body every time I go and pick him up.
Okay, and what do you do in response to seeing these things on him?
I take pictures. I have taken pictures to have as evidence.
Well, as far as treatment?
I used the over-the-counter creams, and I took him to the doctor, and they prescribed to use the over-the-counter. When that didn't work, I took him to his doctor, and he prescribed a hydrocortisone cream. I think that's the name, and it helped him, and it cleared him up.
So, what's the status of the physical conditions you see on him by the end of your weekend?
He's all clear.
Okay, and then
Mr. Gilhart, can you just repeat what's the current parenting schedule? Because I think I lost that.
Oh yes, sorry, Miss Taylor Cruz, what's your current parenting schedule?
From Friday after school.
That's when you pick him up?
Yes.
Okay. So you pick him up Friday after school, and then when do you return him to his mother?
Monday morning I drop him off at school.
Okay. And that's every weekend?
Yes.
Okay.
So basically, she has weekends.
Yeah, sure.
Okay.
So after you've applied the treatment and sent him back to mother, how does he appear when he comes back again?
He has the same thing again.
Okay. Turn in your binder to Exhibit 1. And can you tell the court, let's go one at a time. Do you recognize page 1 of what I've marked as Petitioner's Exhibit 1?
Yes.
Can you tell the court what this is?
It's a rash on his ear.
And when was this photo taken?
April 11,
And can you give her-
2021.
Okay.
April 11, 2021.
And did you take this photo?
I did. Yes, I did.
Okay. And when did you see what is in this photo? Is this Edgar in this photo?
Yeah.
Okay. When did you see this?
On April 11 of 2021.
I mean, in regard to when you picked up Edgar? Or when
yeah, Friday after school.
Okay. Was this on his ear before you sent him to his mother?
No.
Okay. And does this fairly and accurately depict what you just purported it to?
Yeah.
Okay. Let's turn to the second page. Do you recognize this page?
Yes.
Okay. Is this just another photo of the first one?
Yes.
Okay. Does it fairly and accurately depict the same thing you testified at page 1 does?
Yes.
Okay. And then can you turn to page 3? And do you recognize this photo?
Yes.
And what does this photo depict?
These are like rashes or bumps in his back.
And what was the date that you took this photo, correct?
Yes, I did.
And what was the date?
This was November 27 of 2020.
Okay. And at what point in the time sharing was this, during the time sharing was this photo taken?
After I picked them up from school on Friday.
Okay. And does it fairly and accurately depict what you just purported it to?
Yes.
Okay. And can you turn to page 4 of Exhibit 1?
Yes.
Can you tell the court, did you take this photo?
I did.
And can you tell the court what's in this photo?
It's his booty, and it's all red and has like a big rash and dirty.
Okay. And when was this photo taken, the date?
April 23rd of 2021.
And then was this also after picking him up on a Friday?
Yes.
Okay. And were you, when you sent him back to his mother, was that condition gone?
It was gone. He was clear.
Okay. Does this fairly and accurately depict what you reported it to?
Yes.
Okay. And can you turn to page 5? Is this another copy or is this from a different date?
No, this is from a different date. Yeah.
Do you recall what date this photo was taken?
It was November 27 of 2020.
Okay. And did you take this photo?
I did.
And for the record, we're on page 5 of Exhibit 1. And can you tell the court what this photo depicts?
His booty again, with his booty all red with a rash.
Was this also a Friday after picking him up?
Yes.
Okay. And
Well, no, I'll take that back. I'm sorry, I'll take that back because this happened right after Thanksgiving. So he was at the other grandma's house that day. So I picked him up from the other grandma's house. So this was not right.
Okay.
Yeah.
Okay. But does this fairly and accurately depict what
Yes.
you reported to?
Yes.
Okay. And then can you turn to page 6? Can you tell, did you take this photo?
I did.
Can you tell the court what this photo depicts?
It looks like he has like a bunch of rashes. I don't know how to describe it or how to explain it, but he has a rash in his private area.
And when was this photo taken?
This was taken November 27 of 2021.
And was this also after you picked him up on a Friday?
Well, this was the time that he was with the other grandma.
When you say that, what do you, was it in the
Because
care of-
they were out of school for the holidays because it was Thanksgiving. So I picked him up right after Thanksgiving because he was with the other grandma.
Was respondent Ms. Pena with the grandma? Do you know?
I have no clue. I have no idea.
Okay. Does this fairly and accurately depict what you purported to?
Yeah.
Okay. And then move to page 7. Can you tell the court what's depicted in this photo?
It's the rash, the same rash. And that was on November 27, 2020. And this was after I gave him a shower and I was putting on the medicine.
Okay. And was this the, is this another photo from the same date as the one prior to it?
Yeah.
On page 6? Okay.
Yeah.
Does this fairly and accurately depict what you just purported it to?
Yes.
Okay. And then can you turn to page 8? Can you tell the court what this photo depicts?
Yes, it's another picture of his booty all red with a rash. And this was from April 23rd, 2021.
And when was when in the parenting plan was this another Friday after
Yeah.
pickup? Okay. And does this fairly and accurately depict what you purported to?
Yes.
Okay. And then pages 9, 10, and 11. Did you take each one of these photographs?
Yes.
Okay. And do you recall, are these the same date or different
No,
dates?
this different date.
Okay, then let's go through. Page 9, what date is this one from?
This is from March 28th of 2021.
And what does this depict?
His fingernails.
And can you elaborate a little bit on his fingernails?
Well, they're long, dirty, filthy.
And was this another Friday after picking him
Yes.
up? Okay. Does this fairly and accurately depict what you just purported to?
Yeah.
And can you go to page 10 then?
Same one.
This is the same one as 9? Okay, so this is just a different picture on page 9?
Yeah, but it's the same date and it's the same thing.
Okay, it depicts the same thing as page 9?
Yeah.
Okay. Does it fairly and accurately depict the same thing as page 9?
Yes.
Okay. And then can you turn to page 11? Do you recognize this photo?
Yes, this is from April 23rd, 2021.
What does this photo depict?
Has toesy nails that they're filthy and dirty and long.
Was this another Friday after picking her
Yes.
up? Okay. And then turn to the final page. Oh, sorry. Did that one fairly and accurately depict what you purported it to?
Yeah.
Okay. And can you turn the final page on page 12? Can you tell the court when this photo was taken?
This was taken in October 23rd, if I'm not mistaken on the day, because it happened right after he came back to me. It was that same week, that Friday. Yes.
And what does this photo depict?
His toenail, the big toenail, that is coming apart and it was bleeding. And you can just see it there that the whole thing was just coming off.
Ordered it to?
Yes.
Your Honor, I move to admit Petitioner's Exhibit 1 as a
Any
composite
objections?
exhibit.
Any objection, Ms. Kale?
No objection.
Exhibit 1 is admitted.
And Ms. De La Cruz, can you turn to Exhibit 2 in your binder? Do you recognize this first page 1 of Exhibit 2?
Yes.
Okay, can you tell the court what this photo depicts?
It's a mark in his back. I don't know how to describe it. It's a rash. It doesn't look to me like a rash, but it's a mark in his back.
And when did you notice it?
This happened right after Thanksgiving, so it was November 27th of 2021.
Okay, and you took this photo?
Yes.
And does this fairly and accurately depict what you just purported it to?
Yes.
Okay. Can you turn to pages 2 through 5? Are there just additional photos of the same?
Yes, of the same mark.
Okay, each 2 through 5. Can you look at those?
Yes, the same marks. I took several pictures, so it's the same one.
What page are you on right now?
3.
Okay, can you turn to the next page? Is page 4 the same thing?
Yes.
Okay. Is page 5 the same thing?
Yes.
Okay, so pages 1 through 5, do those all fairly and accurately depict what you purported them to?
Yes.
Okay. Can you tell the court what's depicted on page 6?
Well, he had a mark on his knee, and it was taken that same day, November 27th of 2020.
Okay. Does it fairly and accurately depict what you just reported it to?
Yes.
Okay.
What was the date?
What was the date?
This was November 27th of 2020.
And did you say that's the same date as pages 1 through 5?
Yes.
Okay. And then can you tell the court what's on page 7?
This was a mark on his arm. I don't know if it looks like a bruise to me. And this was taken on April 11th of 2021.
Okay, and does it fairly and accurately depict what you just purported it to?
Yes.
And
I'm sorry, Your Honor. I apologize. I just realized the exhibit number 2 I'm missing from page 1 to page 12. I have page 13 to 14 on exhibit number 2. So if Your Honor can allow me 5 minutes for me to download, or if you can share your screen, Mr. Gilhart, that would be really helpful.
I don't want the screen shared on these pictures.
Okay, I apologize.
So have you emailed Ms. Kale the pictures, Mr. Gilhart?
no, they were just filed and served. I can do that now, though.
Okay,
Thank you very much.
just two minutes.
Thank you, Your Honor. It's lilycow at cowlaw.com, or lcow at lilycow.
LKAO, yes.
Yeah, okay.
Thank you.
It's just exhibit 2 you need? Ms. Cow, is it just exhibit 2?
Yes, I'm sorry, I didn't hear you. Exhibit 2, I have the page 13 to 14. I don't know what happened. Just page 1 to page 12. Thank you.
I'm just going to drag the whole exhibit. I have it as one PDF.
Thank you so much. Yeah.
Okay. And I guess from our experience at first hand, it might take a minute or so to get through.
Let me know when you're ready to proceed.
I got it.
Okay, and sorry, my witness just called me. John, please log into Zoom.
Okay. I'm just going to turn my camera off and put on mute. Why don't you just, or are you all ready to proceed?
Yes.
We're ready to proceed. I texted that witness. I'd rather proceed with Miss De La Cruz.
Okay.
And then I call him when I'm concluded with her. So we were on page 8 of, okay, yeah, we're on page 8 of Exhibit 2. Miss De La Cruz, do you recognize this?
Yes,
And did you take this photo?
I did. Yes.
And what is this a photo of?
Of his thigh, I'm gonna say, leg,
And what's on his leg?
a bruise.
Okay. And when did you see this?
This was May 11th of 2021.
Was this after picking up him from Miss Pena?
Yes.
Okay. And does this fairly accurately depict what you just reported it to?
Yes.
Okay. And can you turn to page 9? Did you take this photo?
I did.
Can you tell the court what's in this photo?
Well, it looks like a mark on his eye.
What do you mean a mark?
A bruise. Well, to me, it's a bruise. I mean, you can see it. I took this on, believe it was the same day, May 12th of 2021, if I'm not mistaken. Because I picked them up from school on a Friday, but the photo I took this, it was like the next day. If I don't have my glasses on, I can't really see, what's in front of me. So when I gave him a shower, I noticed the mark. And I took him to give him a shower, and I noticed the mark and I took the picture.
Okay. Does this fairly accurately depict what you purported it to?
Yes.
I'm having trouble seeing the mark. Are you saying the whole eye is like a black eye, or where is the mark?
Do you have color photos, Your Honor?
Yeah.
Okay. Do you mean a bruise or a mark?
To me, it looks like a mark. And it's all red. I mean, you can see. It looks like somebody hit him there, in my opinion, in my eyes.
Okay.
You want me to continue, Your Honor?
Please proceed, Mr. Gilhart.
Okay, thank you, Your Honor. And page 10.
It was the same one.
Oh, is this a copy
Yeah.
of the same photo?
Yeah,
Okay.
the same one.
And then can you tell the court, go to page 11, the next page.
Which one?
Oh yeah, it looks like the Bates numbering. I had to use white font on these photos, so Exhibit 2, it says page 01, and then it would have been white, but we're on the next page after page 10. Can you tell the court, did you take this photo?
I took this picture from another picture. I don't know if I explained myself.
Oh, so this is a screenshot of a photo?
Yes.
Okay. What's depicted in this photo?
You can see he has like a big scar on his chin down here. And this was from 2017. I don't know the exact date because he was with her and the other grandmother and grandfather.
This was you said from the year 2017?
Yeah. This one here, yes.
Does fairly accurately depict what you purported it to?
Yes.
Okay. Can you turn to page 12? Can you tell the court, did you take this photo?
I did.
Okay, when did you take this one?
This was right after Easter on 2019.
Okay, and what does this one depict?
He has a bruise on his lips.
Okay, and when when did you see this in relation to picking up him from Ms.
It
Pena?
was, I think I picked him up on Friday, if I'm not mistaken. So I picked him up from her house that day,
Okay.
not from school.
Does this fairly accurately depict what you purported it to?
Yeah,
Okay. And it's page 13, another photo.
it's the same
12.
thing. Yeah,
Okay. And does it fairly accurately depict what you testified number 12 depicts?
yes.
Okay. And what's exhibit
The
2,
same
page
thing.
14?
It's the same picture.
Okay. Well, is it the same or is it from a different angle?
It's a different angle. It's the same picture, but from a different angle. I
Okay.
took several pictures. Yeah.
Okay.
And these are all from 2019?
Yes.
Okay. Were you exercising the plan at that time?
Yes.
And so this depicts the same thing as pages 12 and 13?
Yes.
Okay. And it fairly accurately depicts what you testified those do?
Yes.
Okay.
Can I say something if I'm allowed? Or no?
What would you like to say about this photo?
Okay, this happened when she stopped me from seeing him right before we brought her back.
Objection, Your Honor. Not responsive. I mean, cause
Correct. So sustained. Mr. Gilhart, can you ask questions?
Yeah, I'll rephrase. Miss Pena, when did this photo occur? Sorry, I said Miss Pena. Miss De La Cruz, when did this photo
This
occur?
happened right after Easter in 2019.
Okay, when was this in relation to the time that you were exercising with Ms. Pena?
It was during the time that they allowed me to share time with him. But then after this, she stopped me from letting him see him.
What do you mean after this?
Right after this, I didn't see him anymore. She refused to let me see him.
After you saw this?
After I took this picture, it was right after this.
Did you tell her?
Yes, I remember texting her and letting her know about it.
And then after that, she didn't let you see Edgar?
Yes, she tried to say this other story about it, I don't know how to explain it, but right after, all I know is that right after this, she stopped me from seeing Edgar, that I had to call the cops in order to enforce the order. And that's
when you
yes. Yes.
Your Honor, I move to admit composite exhibit 2.
Any objections?
Exhibit 2.
no objection, Your Honor.
Exhibit 2 is admitted.
Thank you, Your Honor. So all these, strike that, sorry, Your Honor. So these all went to the physical concerns. Do you have any behavior concerns over Edgar's behavior?
I do.
And what behaviors have you witnessed that cause you concern?
He hits, he gets very aggressive, he goes into a rage, he kicks doors, he kicks walls, he's very, very, very aggressive.
Do you have any pets?
I do. Well, I wouldn't call it, because they're chickens, yeah.
And has he exhibited any behaviors towards the chickens?
Yes, he has tried to hurt the chickens.
What do you mean by that?
Like, he's like, oh, I'm gonna beat the shit out of, this chickens.
Hearsay, Your Honor. Objection.
Overruled.
Have you witnessed any sexualized behaviors?
Yes.
And what are those?
Oh, he has played with the dolls. He has like a Spider-Man and a Batman dolls that he spread their legs and he leaks. I don't know if I'm saying the right word. With his tongue, he licks their private part.
Of his action figures?
Yes.
Okay.
And with a teddy bear, he opens up the legs and try to stick his finger in there in his booty. on the teddy bear. He has tried to go in and see me when I'm taking a shower. He wants to see me naked. There's a numerous of things that I wouldn't be able to finish telling you today all. I mean, there's a whole list of the things.
Have you seen any sexualized behaviors when he uses the restroom?
Yes.
What did you witness?
When it's time to give him a shower, when he takes off his clothes, he goes in front of the toilet and he humps the toilet and acts like, it looks like he's having sex with the toilet.
Has he exhibited any sexualized behaviors toward you?
Yeah.
What did he do?
He has tried to come on top of me and try to put his private part in my face. Okay. That I have to push him away from me and tell him to stop. That's inappropriate.
Okay. And now with regard to, did you have any concerns over his mental health?
I do.
Okay. And Your Honor, just as a premise, I am going to elicit some of the things the child said. All these statements are not offered for the truth of what the child is stating, but merely that it's a concern of mental health, and that's why we're seeking a guardian ad litem. I'm not trying to prove anything the child is asserting.
Thank you.
Ms. Taylor Cruz, what things have you heard him say that cause you concern for his mental health?
That he wants to kill himself, that he hates his life, that he can't take it anymore. He has tried to choke himself. I had to pull to the side of the road one time and told him to stop because he was putting his hands around his neck and he was trying to choke himself.
And that's more of a behavior. Is there anything else that he says that caused you concern?
Yes, that he constantly saying that he hates his life, that he wants to kill himself, that he doesn't want to live anymore, that he wants to die. You know, all those things. I mean, I could sit here all day and write a book.
Well, I'll ask you the questions. Does he swear?
A lot.
What does he say?
Shut the fuck up, you stupid bitch. You motherfucker. I hate you, you stupid bitch. You know, things like that.
Immediately when you got him back from Ms. Pena's care from the contempt order, did he say anything immediately thereafter that concerned you?
Yes. The first thing he said when he walked in my door, he said, "You're a kidnapper. You're a kidnapper, Nana." He's like, "It's the truth that you went in front of the judge."
And when in your time, so if you pick him up Friday, when do you hear these types of statements most frequently?
Right after I pick him up.
And how long does this type of behavior and these statements last?
Well, for Friday, when I pick him up from school, he's like that. He's very aggressive. He gets like that. Then after Friday, Saturday, Sunday, he's more calm. And he keeps asking me, "Nana, what day is today?" When I'm going back to my mom. And then when he knows it's time to go back, he begs me. And he's like, "Please, Nana, please don't take me back to my mom's."
Does he have any trouble sleeping?
He does.
And how would you describe that to the court?
Because he hears me get up or he hears the door, he gets up in the middle of the night. Nana, where are you? And he starts looking around, and then when he knows that I'm there, he's like, okay, I'm safe. I'm here. And my daughter knows this is not a lie because she has seen him doing that when she used to live with me.
Okay. And has Ms. Pena had any issues with Edgar's care in the past?
Yes.
And what was that?
DCF removed Edgar from her and put him under my care in 2016.
And how long was that?
For about 4 or 5 months.
And what was were you supervising her?
Yes.
Did she live with you?
No, she didn't live with me. That was a condition, but she refused to move in with me. So she would come and visit Edgar at my house, so I had to supervise the visitation.
And how often did she come to visit with Edgar?
I think it was twice a week, if I'm not mistaken. I can't recall the exact dates, but it was twice a week.
Okay. Were there any issues at that time that you saw with her parenting of Edgar?
Yes, she would come, play with him for a little bit, and then maybe like 15 minutes after, I would go in the room, she was asleep, and Edgar would be just, on the bed playing by himself.
And then, I apologize, Your Honor, I skipped a question. With regard to exhibits 1 and 2 and all those photographs, are you able to tell me how he got any of those, what you purported to be in those as bruises? Are you able to tell me how he got those without telling me what he told you?
No.
Okay. And have you been looking to help him with any of his issues in any way?
Yeah.
And what have you been trying to do?
I have trying to get counseling for him, or therapy, some type of treatment or something.
And have you run into any problems getting one?
Yes.
Okay, and what's that?
The time. So I only have him from Friday after school till Monday morning.
Have you talked to Ms. Pena about it?
Yes.
And what has she said about it?
She refused.
Okay. Is that why you filed your supplemental petition?
Yes, I did.
Okay. And do you have concerns over Ms. Pena's drug usage?
I do.
And why is that?
Because she has used cocaine in the past.
Okay. Have you observed anything to make you think she's used cocaine?
Yes. Her, how do you say it, irrational behavior. Because I don't smell any weed, I don't smell any alcohol, and her behavior is just irrational. It's not.
Okay.
I don't know how to explain it.
Okay. Are you, do you have any mental health concerns over Ms. Pena?
Yes.
What are those concerns?
Well, she was diagnosed with bipolar when she was a minor, when she was under my care. And she was on treatment until she turned 18.
Okay. So, are you aware of any treatment or medication she's taking now?
No, I don't know if she is or not.
Was she taking medication while she was in your care?
Yes.
Okay. And so are you requesting a substance abuse evaluation and random drug testing of Ms. Pena?
Yes.
Okay. And are you requesting a guardian ad litem be appointed to represent the best interest of Edgar and opine to this case and the issues?
Yes.
And do you agree to advance the cost of the guardian ad litem without prejudice, subject to reallocation at a final trial?
Yes.
Okay. And same with the mental health evaluation and drug testing. Do you agree to advance the cost of that?
Yes.
Okay. I have no further questions, Your Honor, for this witness.
Ms. Kale?
Yes, Your Honor. Thank you. Good morning, Ms. De La Cruz. Okay, so the pictures that you took of Edgar, so please help me with the dates here. Okay, so you're saying Exhibit 1, page 1, you took it on April 11th, 2021, am I right?
Yes.
Okay, so that is a Sunday. So that's not a Friday right after you pick him up, am I right?
You're right.
Okay, and so the same goes on with exhibit number 2, page 8 and 9. Your testimony was those pictures were taken May 11, 2021. Am I right?
This is where she's at?
Exhibit 2. Yeah, Exhibit 2.
This one.
Yes.
No, pages 8 and 9. No, wrong way. Wait, are you in? Sorry, she's still in Exhibit 1.
It's okay.
Okay. She's there on page 8.
Thank you.
This was on April or May 11, if I'm not mistaken, of 2021.
Okay, so May 11, 2021 is a Tuesday.
It's a Tuesday.
Okay.
Can I respond? Can I? Oh.
That's a yes or no question. So,
Yes.
okay. So, Exhibit 2009, it was your testimony that you took this picture on May 12th, 2021.
Yes.
Right? Okay.
Yes.
That's a Wednesday. Okay. So several of these pictures were taken on the same day.
Yes.
Am I right? Okay.
Yes.
So when you found out about these bruises and signs of your concern, your first reaction was to take pictures. Am I right?
No. No.
Okay. So did you call DCF about it?
I did. On several of them, I did.
Okay. What did they tell you?
Were they? No.
Sustained.
Okay. Was there any DCF investigation?
Yes.
Okay. What was the result of those investigation?
Objection calls for hearsay.
Sustained as to the way the question was worded. It could lead to a hearsay answer.
Okay.
If you want to rephrase, Ms. Kao.
Yes. Okay. I'm going to move on.
Okay.
So, did you contact Ms. Pena about your concerns after you took those pictures?
I did.
Okay. And when you took those pictures, I mean, is it, I guess, okay, let me rephrase. Do you think it's normal for you to take pictures of Edgar whenever you see a bruise or see some signs on him?
And should I answer? In my opinion, yes, because I am concerned for Edgar's safety.
Okay, so is it fair to say that he already knows every time he has something going on and you would take a picture of him?
No.
Okay.
No.
Okay. That's fine. So all the pictures and bruises and the rashes, after you've contacted my client, and was there any signs of improvement?
From her side, no.
Okay. Okay. Did you contact her about it? I mean, do you know?
I did. I sent her several text messages asking her.
Okay. So about Edgar's behavior concerns, okay?
Yeah.
So do you agree that he, as a 5-year-old boy, it is not uncommon for them to explore sexual aspect of, I guess, his body?
Objection. This kind of calls for improper opinion. I don't know that a layman can testify to age-appropriate behavior.
Sustained.
Okay. Okay. So after so were you the only one, I guess, heard those comments about choking himself, suicidal, or using cuss words by Edgar?
Not only me. There's my daughter too. His aunt.
Okay. All right. Did you testify? You testified at the 2017 divorce trial of Ms. Pena, am I right?
Yes.
Okay. So is it your opinion that she is not a, I guess, a competent mother, like a good mother?
When I testified at the time, she was with me. She was staying with me. And I make sure that she took care of Edgar. I make sure that she did all the things that needed to be done for Edgar.
Okay.
And she knows I'm not lying.
Well, that was a yes or no question. Do you think or do you not think? Okay. So it is your testimony today that she is not a competent mother. Am I right?
You're right.
Okay. And Your Honor, if I may direct the witness to Respondent's Exhibit 1, the final judgment of dissolution and parenting plan.
You may.
Page 3 of 11.
Are you going to share your screen? Sorry.
I can, but I guess I'll.
Sorry, I don't have Exhibit 1 printed.
If I may share the screen, Your Honor.
You may.
Thank you. Okay, paragraph number 7. Can you read it where the cursor's at?
I can't see anything.
Yeah, I think you need to zoom in.
Thank you. Let me try to do that. Is that big enough, or I can blow it up more? Sorry about that.
I'm pulling the computer closer.
Okay, I will blow it up bigger.
Okay, what part?
Paragraph number 7.
Okay.
Here, where my mouse is at. I wish I had the ability to highlight.
You want me to read it?
Yes, please.
Okay. It says the petitioner testifies she was always been very involved with the child. The petitioner testifies she gets the child up, brushes his teeth, takes the child to daycare, picks him up. She testifies she takes the child to. My glasses are getting foggy. But I remember every word I said, so I don't have to read it.
Okay. So it was your testimony then that Ms. Pena was a good mother, very responsible. She spends hours playing and laughing with the child.
Yes. When she was at my house, when she was with me, because I make sure she did that with him. And she is right there. She knows I'm not lying because I was on her all the time.
Your Honor, objection, not responsive.
Overruled.
Okay.
This is from 2017, right?
Yes.
This is well before the temporary order, correct?
Yes.
Yes.
Okay. Just making sure I knew the lay.
So I'll exit. I'll stop sharing. Okay. So Ms. De La Cruz, so I mean, my client has never neglected Edgar, am I right?
Almost testifying, sorry.
Okay. Has my client ever neglected Edgar?
I would say yes.
Okay. Has she ever abandoned Edgar?
Yes, she did. When she stayed with me, a lot of times, she would take off at 2, 3 o'clock in the morning without even telling me that she was taking off.
Okay. Has she abused Edgar, in your opinion?
She tried to hit him several times, but we put a stop to it, and she knows that.
Okay. So it is your request today that you want more time with Edgar. Am I right?
I want him to be able to be seen.
Not responsive, Your Honor. Objection.
So yeah.
Overruled. Let her finish.
Okay.
So I continue?
Yes.
I want Edgar to be seen, to get help, to get treatment.
Okay. So if my client can get Edgar the treatment he needs, you don't really need to ask for more time with Edgar. Am I right?
Is she asking? Is she asking for more time? Maybe I missed that part.
No, I'm saying, you know, I'm sorry, Your Honor.
No. I just want to make sure I'm not missing something.
No, Your Honor.
Is your client asking for more time?
That's in the supplemental petition is seeking a modification, but not for today.
Not
we're
today.
just requesting a gal.
Okay.
So, yeah, let me rephrase. I'm sorry about that. So if today my client can get Edgar help, do you think it's still necessary to have a guardian ad litem appointed? Okay. And about my client's irrational behavior, you know that, am I right that your relationship with her right now is not the best? Am I right?
Right, yeah.
Okay. And without, okay, so she is frustrated with you, am I right?
Yes, but this is not from just now.
And the irrational behavior that you talked about, it was a sign of her frustration, am I right?
No, that's not right. So I know my daughter.
Okay. So other than that you saw some irrational behavior of her, you do not have any other corroborating evidence to support, I guess, having her subject to a substance abuse evaluation or drug testing.
I saw her in her shoe one time. I found a little bag of Coke. It didn't have no more Coke in it, but it had the residue of Coke. And I questioned her, and she did not deny it.
When was this?
She was still pregnant at the time.
Okay.
That was 5 years ago.
Yeah.
Okay. And, okay. No more questions, Your Honor.
Okay, redirect, Mr. Gilhart.
Yes, Your Honor. Exhibit 1, in the interest of time, I'll turn to my binder.
Okay.
I'm showing the petitioner Exhibit 1, page 1. You just testified this was taken on a Sunday. What is that? Is that because you noticed it on a Sunday?
Yes, it happened. What happened that week that I picked them up? So it happened through those days. I picked them up on Friday, and I have him till Monday morning. I did say Friday. I can understand why she questioned me, because the date don't match. But it happened during that time that I had it, from Friday till Monday morning of that week.
So you noticed it on?
Yes.
Okay. His mother's care?
Yes.
Then and pages 8 and 9 that you testify as to these bruises on Edgar. I guess you testified these took place on May 11th. Is that right?
Yeah.
Okay. So when did you pick up Edgar to get him on those dates?
I think he was either from school break or something like that. I don't remember the exact date, but it happened after I picked him up, during that time that I had him.
So did immediately before this, the most recent time before this, when you had time, did you observe any bruises on him like this? So not this, when you took this picture, okay. Alma had him, Ms. Pena had him in his care before this, correct?
Yes.
Okay. Now before that, whatever weekend before that, did you see these bruises on him before returning him to his mother?
No.
Okay. And then after
Yes.
he was in care of Ms. Pena, you saw these?
Yes.
Okay. And no further redirect, Your Honor.
Ms. Pena,
Yes.
you're stating in this petition that your daughter has neglected Edgar. Why, in your own words, since the court has entered the order, are you stating that she has neglected him? How has he been neglected?
Well, you can see the rashes on his private area. I took him twice to the emergency room because he gets so constipated. He cannot, go to the bathroom. The doctor just prescribed Miralax. When he's with me, I make sure I give it to him, and he complains that, he can't go to the bathroom, that he can't poop, and he has a really hard time. One time at the daycare, when he used to go to daycare, the same lady from the daycare, she was about to call DCF and let them know the condition. In her eyes, that was being neglect. That knowing that Edgar could not go to the bathroom and he was at risk of his
What is it that you're saying? What is it that you're saying that your daughter did or did not do to cause that?
The medicine, giving him the Miralax, making sure he gets the Miralax. The rash is inappropriate hygiene.
Okay, so what you're saying is not that she caused the rashes or the constipation, but she's not treating it appropriately?
Well, yeah, you can say that, but the rashes, the doctor from the hospital said that was for having a poor hygiene. So to me, in my eyes, that's being neglect.
Have you discussed these hygiene issues with your daughter?
Yes.
What does she say?
She says that he does gets a shower, but she tells me I really don't know. From the condition I picked up Edgar on Fridays, he's filthy, he's dirty, he smells bad. You can see by the pictures on his fingernails, toesy nails, that if she was taking care of him, he should not be like that.
Have you seen any changes in his hygiene since you've brought these conversations, or you've had these conversations with your daughter?
No, because it's me the one who cuts his fingernails. It's me the one who takes him to get a haircut. It's me the one who does everything for him. So when I take him back, he's fine. But when I pick him up on a Friday, he's dirty. He smells bad. He's not clean. I mean, even his teeth. I mean, you can look at his teeth and see that he doesn't get his teeth brushed.
Do you have any evidence
of what?
That your daughter is taking drugs since the 2019 order? Or I'm sorry, the 2019 petition?
Evidence as if I have seen her myself, no.
What's the basis?
The basis
do you believe
is
that she's still abusing or is abusing substances since 2019?
Because the girlfriend that she was with, that she passed away back in October, she was a heavy user of cocaine, and she was doing it too.
So because her friend was a heavy user?
Yes.
Any other evidence?
Other than that, no.
I have one more witness, Your Honor, too.
Okay. All right. I just asked a bunch of questions. Mr. Gilhart, do you have any questions as a result of the court's line of questioning?
Yes, briefly, Your Honor.
Okay.
Okay. And Ms. Pena, as it relates to abuse, abandonment, neglect, are you also concerned over the sexualized behaviors that you're seeing? I'm asking you. Yes. Oh, sorry. I said Ms. Pena. Yeah. Ms. De La Cruz. Ms. De La Cruz, as it relates to abuse, abandonment, neglect, are you also concerned about the sexual behaviors that you're witnessing from Edgar?
Yes.
Okay. And do you have concerns over his mental health and any mental injury that might be a result of things that he's seeing?
Yes.
Okay. And the bruises that you took photos of and the bruise on his eye, do you know how he got those?
No, I don't.
Okay. But they happened prior to you getting him? Okay. No further questions, Your Honor.
Ms. Kao, do you have any questions
I have
within the
just a
scope of the
couple.
court's line of questioning?
Yes,
Okay.
Your Honor, I just have a couple of questions. Ms. De La Cruz, are you aware that Ms. Pena has been giving Edgar the cream for his rashes?
Yes, because I brought the cream myself to her, and I asked her to make sure to put it on.
Okay, thank you. And so do you pick up Edgar, that you agree that you pick up Edgar on Fridays after school?
Yes.
Okay, so do you agree that Edgar, as five-year-old boy, lives a pretty active life?
Yes.
Okay, so are you aware that Ms. Pena takes Edgar to parks or other like playgrounds with physical activities at least twice a week?
Yes.
Do you agree that it is possible for Edgar to have bruises from those activities?
Yes, it's possible.
Thank you. No further questions, Your Honor.
Your Honor, may I ask one redirect question?
No. We've already gone back and forth enough. Do you have, who's your next witness, Mr. Gilhart?
Miss Lindsay Pena.
Okay.
You can sit there. I'll go get her. If she's not in the Zoom, she's in my office in the lobby.
Good morning, Ms. Pena. Can you please raise your right hand and be sworn in by the clerk?
Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
We couldn't hear you. Is the mic on?
Yes.
Yes. Okay, can you please state your name and date of birth for the record?
Lindsay Pena, 1219 of 97.
Okay. Please proceed, Mr. Gilhart. And Ms. Pena, you can put your hand down.
Ms. Pena, what is your relation to Miss Alma Pena?
I am her sister.
Okay, and have you witnessed your sister parenting?
I have in the past. She's very careless. She doesn't really.
Hold on, I'll ask you some follow-up. Have you observed anything that concerns you within the last year regarding her parenting?
Within the last year, yes, I have.
What have you seen?
Specifically that she is very careless when Edgar is with her, in the home that she was last time that I visited her in. He would just go about doing anything, go on the streets. She wouldn't really like keep an eye on him as much as she should have, be attentive.
What do you mean he would go on the streets? Would she let him outside?
Yeah, she would definitely let him outside. The area where it's at, there's quite easy access to the road, so that's obviously a hazard.
Would she go outside with him?
She would be outside in the front, but necessarily right next to him, no. And this was when he was about 4.
Okay. Was she supervising him?
I would say she kept an eye from afar.
Okay. Have you ever resided with Miss Pena?
I did have to spend a night with her when I was contacted by GCF to be a supervisor for the night. I had to go over and spend the night in his bedroom.
And did anything concern you about that night stay that you had there?
Yes, actually, when we woke up in the morning, he went to go get breakfast, and I heard a loud screech from him. I want to say that I heard my sister hit him for whatever reason. I'm not sure. It didn't sound like there was any reason to hit him, but I heard a loud scream from that kitchen.
Do you have any concerns over oh wait, sorry, no. Have you heard anything that Edgar said that has caused you concern over his mental well-being?
Yes, I've heard him say numerous times that he wants to kill himself, that he wants to die, and that just is very worrisome for me. I don't understand where that's coming from, because when he is with my mom, he's very happy, very friendly, very social. But whenever it's the week coming back from his mom's, he's always very aggressive, residing to himself, very reserved, doesn't like to be social, friendly. So that's a worry on my hand, where that attitude and behavior and comments are coming from.
So have you observed Edgar immediately after your mother picks him up?
Yes.
Okay. And how would you describe his behavior after he's picked up?
In the beginning, very reserved, but as the day goes by, he gets very social, friendly, very like gentle, nice.
But initially, is he aggressive?
Initially, he is very aggressive, very reserved, doesn't want to talk to anyone.
And are you aware generally of the concerns that your mother has over Edgar's health and well-being?
Okay.
Are you aware just generally of your mother's concerns over Edgar's health? Okay. Do you in any way think she's overreacting to these concerns?
No, I don't. I think she has reasonable concern regarding his health, well-being, how he's taken care of at home, if he's getting the proper hygienic care that he should be getting, if he's in safe hands, if he's away from potential danger regarding other people who my sister surrounds herself with.
Okay. And have you observed how Edgar behaves when it's time to go back to his mother's, or immediately the day before?
Yes. He does not want to go back. He's always screaming. He's always yelling. He's always wanting to stay with my mom. He's always fighting. He's always throwing fits when my mom hands him over, when we dropped him off before at my sister's. He doesn't want to go. He didn't want to get out of the car one day when I dropped him off. He did not want to leave.
And do you have any concerns over Ms. Pena using illegal substances or narcotics?
In front of me, no. But there have been incidents when the father of Edgar's, when I had went over to their place one time to pick Edgar up, I did have that smell or sense that smell of weed or even possibly coke.
In her home?
In her home that she was staying at that moment.
When was that?
This was when Edgar's father was still out. before he went to jail.
Oh, okay. Do you recall the year?
I want to say when he was around a year old. So when it was like 2016.
Okay.
Yeah.
And are there any other signs that you feel demonstrate she might be, well, are there any signs that you feel like she might be currently abusing substances?
The only thing that I can say is that I am unsure when she did ask me for money. I am unsure where her paycheck goes to. If she's behind on rent sometimes, or she can't afford oil for her car, I believe she had asked me for one time. It was very odd when I asked her where her money was going to. She didn't want to explain where her money was going to. So that immediately there was something that I was concerned about.
And when's the last time you spoke with Miss Pena?
This was about October. Yes.
Okay. Why haven't you spoken with her since then?
She doesn't want to have contact with anyone in the family. She believes that we're all trying to take Edgar away from her, and that's not what we're trying to do.
What are you trying to do?
We're just trying to make sure that he is in good hands, that he is well taken care of, and addressing the issues that need to be addressed in terms of her parenting.
And how recently have you seen Edgar?
I saw him 2 weeks ago.
Okay. And you've seen these behaviors and your concerns up until then?
Yes.
Okay. No further questions, Your Honor.
Ms. Cahill, cross-examination.
Yes, Your Honor. Good morning, Ms. Pena. I just have a couple of questions for you. So how do you describe your relationship with my client?
We currently aren't in speaking terms. I do want to talk to her and I do care for her, but she just has chosen not to speak to me.
Okay. Well, thank you for your answer. And so you currently do not live with your mother, am I right?
No.
Okay. So how often do you go over to her place?
How often do I go over? I would say every month or every other month.
Okay. Every other month. So it is not possible for you to see Edgar every weekend that he's there with your mother. Am I right?
Right.
Okay. So, and it was your testimony that your last contact with Ms. Pena, with my client, was back in November last year.
Right.
Okay. And are you aware that she had to later, hire an attorney and basically support herself and Edgar, and she's working full-time now?
I wasn't aware that she was working full-time, but the rest, yes.
Okay. All right. And about the concerns that you had for Edgar, did you try to address that with my client?
She actually has blocked me on everything, and I have tried reaching out to her, so I've been unable to speak with her about those incidents. But prior to her blocking me, I would ask her. She wouldn't give me any valid reason. She would just bring up how she doesn't know why he says or acts like that. So.
Okay. Thank you. And for abusing drugs allegation that you brought up earlier, so the last time you, had any suspicions or anything was at least from last year? From whenever that was the DCF case was the last time, that was in 2017, am I right?
The last DCF case, I think that was in 2019.
Okay.
I had to go over to her place. Okay. Yeah, it was.
Okay. And that it was your testimony that you heard Edgar scream.
Yeah.
Am I right? And while you were in another room.
Mm-hmm.
And you did not see my client hitting Edgar.
I did not see, but I heard a loud smack, and then his scream followed it.
Okay. And did you address that with Ms. Pena, with my client afterwards?
I did not. I didn't want to make a scene. I was there to support Edgar and be there to supervise him, which I probably should have, because I was the one that was supervising him, supposed to supervise him, even though I was there, saw that.
Okay. Your Honor, I have no further questions for this witness.
Can you redirect?
No, Your Honor.
No? Okay. All right. Thank you. Thank you very much, Ms. Pena. You can exit the room.
Yep, you're good.
Mr. Gilhart, please bring back in your client.
Okay, she's here. She's sitting here.
Okay.
Here. Ms. Taylor, Chris, you can sit here.
Okay.
I'm here.
All right. So this hearing was unfortunately only scheduled till 11 today. So we're already over time. So let's just briefly take a step back, because I'm assuming that you have other witnesses, Mr. Gilhart, at least one that you subpoenaed that's not here.
It's only that one. He's the last one.
And I'm assuming, Ms. Ko, you were going to want to be putting on evidence with respect to your client.
Yes, Your Honor.
So let's take an important step back right now and start talking about what's important. What's important is Edgar. I'm not making any finding today, as I can't. The hearing is not done as to whether or not, Ms. Pena, you are a fit parent or you've neglected the child. But the evidence I've heard today was a little bit concerning, but not totally impressive yet. But fitness and maturity are two completely separate things. It's going to be time now to show your maturity. And that's going to go a long way to the court in determining what to do here. Part of maturity is going to be how you're treating your family, including your mother, who has obviously gone through great lengths to take care of Edgar for a long period of time, and also how you treat the rest of your family. Edgar's made some concerning statements, at least in the evidence here today, about wanting to kill himself. Those are very unusual statements for a 6-year-old. Maybe part of the stress of the situation that he's in, going back and forth and having this type of custody issue. Ms. De La Cruz wants him in therapy. I think the court believes that he absolutely should be in therapy. Ms. Ko, is there any reason why we can't come to an agreement right here and right now to get Edgar into therapy?
I don't believe so, Your Honor. And
okay.
Yes.
Let's do it right now, because I'm not going to be issuing an order on determining fitness yet, because we haven't heard all of the evidence. But there is zero reason why we can't get him in therapy right now. So, Mr. Gilhart, or I guess it doesn't really matter. Do we have any particular therapist that we know of that we want to do this therapy?
I don't have any prepared right now. I have a couple that I know are good. Off the top of my head, I think probably could call Mary Shorak. I think she might be able to handle this case. I could email Ms. Cowell today,
Yes.
like 3 proposed. And
Sounds great.
Yeah.
So if you guys can't agree on a therapist, let me know within 5 days and send me your proposed list, because I'll just select.
Okay.
It's that important. In fact, it's much more important than just the decision of where Edgar's going to spend the weekends. The second thing is, I do think it would be a great idea to have a guardian ad litem appointed here. Especially because it does appear that Edgar has something to say, even as a 6-year-old, and I'm not going to call him into court to hear it. I would like to appoint a guardian ad litem as requested by the father. I'm sorry, not the father, the petitioner. And so I will be ordering that here today. I want that to happen quickly as possible for the assessment by the guardian. And I'm going to want to hear from the guardian when we reconvene, and we're going to reconvene very soon. So let's get that order out as quickly as possible. As it relates to the request for substance abuse evaluation, I am not going to order that here today. There was zero evidence that I heard that had anything to do with any newish allegations of substance abuse. The best that I heard was that she may have taken an illicit substance way back when she was still living with the husband. And that was some time ago. There is nothing that I heard today that was convincing that's going to have the court order it today as a requirement. However, and again, this is going to go back to your maturity, Ms. Pena, there is nothing that stops you from doing that. There is nothing from you to have a test done to show both your mother and the court that you are free from substances. As of right now, I don't have any reason to believe that you have taken any substances. Obviously, it's a concern by your mother, and it's a concern based on stuff that's happened in the past. It's not out of nowhere. It would be a very mature thing to do. But Mr. Gilhart, that's not going to be part of the order here today. I want to reconvene this as quickly as I can. The unfortunate thing is that we need a little bit more time. And I do think it would be good to have the guardian ad litem have a little bit of time to do their work. My goal would be to hear this sometime near the end of the summer. Although I want you both to work with Cheyenne regarding scheduling this for a time. In your order, Mr. Gilhart, please emphasize that the hearing on the motion to terminate the temporary order has not concluded.
Yes, Your Honor.
Mr. Gilhart, do you have any questions with regards to the court's order today?
No, Your Honor. I guess the GAL is granted, the substance abuse is denied. Can I put, I guess, without prejudice? Yeah, without prejudice. And then I'll just put the motion just continued, I suppose. The court reserves, the motion's continued.
The motion is going to continue because of what the hearing was not able to be concluded.
Okay.
Your Honor, I have one question about
Yes,
the appointment of guardian ad litem. The cost of it, I know that in the motion, it was stated that Ms. De La Cruz would fund the cost and subject to any allocation by the
Correct.
court. So,
Yeah. Do you have any other questions, Ms. Kao?
no, I don't.
Your Honor,
Mhm.
if I may, I wanted to refer back to the exhibits. The exhibits aren't viewable by the public. We can still steal them if you want us
Yes.
to go ahead.
Yes.
Okay.
Yes. Thank you. Thank you, Stephanie. I really appreciate you bringing that up. Yes, I definitely want to keep those sealed.
And I'll submit an order to that as well, Your Honor.
Okay. Thank you.
And the
Is there
court
anything
rules-
else the court can do today, or we could come to an agreement that would help Edgar?
Your Honor, if I may make a suggestion, is it possible for parties to go to mediation at this point? Or that's not
I
something?
would love nothing more than for the parties to go to mediation, but have you already been to mediation? Because I don't want to order it on top of it. There's nothing that ever stops the parties to go to mediation.
Okay, I guess I'll work with Mr. Gilhart on that one.
I could tell you what I see here. I could tell you what I see, and I don't know if this is going to help.
Okay.
This is a temporary order giving petitioner temporary custody. Its very design is that it's going to end. Its very design is that it's going to end unless you can meet a very, very heavy burden, a very, very heavy burden to show that your daughter has neglected the child. So far, what I've heard today does not seem like it's approaching that. However, the relationship that you have with Edgar doesn't have to end, and it shouldn't end. You've built a strong bond for everything that you've done with him over the time. And again, this is going to go back to what's under the law versus what's the mature thing to do. And the mature thing to do would be for you all to be able to come to an agreement to basically end, but also making sure that Edgar has time with his grandmother and his family, and also that you honor your mother in what she's done for both you and what she's done for Edgar up to this point. Again, that's I would much rather see this family come together and decide that for themselves than for me to make that decision.
I mean, needless to say, we really appreciate Your Honor's insights on that. And then the reason I brought it up is just the financial and mental burden on Ms. Pena to have to constantly going back to court. That's why I wanted to propose, if it is possible, for us to go to mediation. But I guess I will work with Mr. Gilhart on that.
Yeah, and Ms. Cow, I think once we have the guardian ad litem report, I mean, that report is probably going to say everything we need to have a meaningful conversation and try and resolve this. So
thank you.
Yeah.
Okay. Any other questions or anything else the court can help with in this situation?
The court approves of Rebecca Beto as the guardian ad litem.
I don't approve her yet. That's fine with me. I haven't had the opportunity to see her work one way or the other yet, so I just.
Okay, and she sent me a proposed order already, so I'll get that up as soon as I can. Okay.
All right. Best wishes to Edgar and best wishes to this entire family.
Thank you.
We'll reschedule and we'll get back to conclude the hearing.
Thank you.
Thank you. Ms. Dines, are you here on the next one? Nope. All right.
I am not.
Bye, Ms. Dines.
Bye.
Good morning, Ms. Talrico. Good morning, Ms. Cohn.
Morning, Your Honor.
And good morning, Mr. McKee.
Mr. McKay, we can't hear you yet. You're not connected to the audio.
Ms. Talrico, I think you're not connected yet either. Good morning, Mr. McKee.
Good morning, sir.
Good morning, Ms. Talrico.
Morning, Judge. I have Ms. McKee here in my office. Let me just.
Good morning, Ms. McKee.
Morning.
All right. So we're here today on Ms. McKee's motion to reopen the case as it relates to evidence of travel expenses. Ms. Talrico, please proceed.
Judge, I just want a little bit of housekeeping. I just want to make sure we're all on the same page. Today, Ms. Khan didn't want to go forward on any kind of evidentiary I mean, of course, it would depend on the court's ruling today. I just wanted to make sure that that is still the plan here.
Yeah.
Okay. 'Cause we didn't prepare for
Because
it.
this wasn't set for evidentiary, I don't believe, right?
Right.
Okay, yeah.
Okay. And if the court does deny my motion, there are still several outstanding matters. We do have a June 30th date pending. Is it possible to use that date to, I guess, kind of clean up whatever else we have left over? Would you be okay with that?
I don't have any issue with it, but it doesn't seem like that should be problematic, is it, Ms. Cohn?
No, Your Honor, I'm just not exactly sure what additional issues there would need to be resolved where we would need that court date.
I'm not either, but I do know that that's probably the last chance that we'll have before the summer.
Right. There was a matter of equitable distribution payment. There was several things that were left out of the final judgment.
Okay.
The manner of equitable distribution payment, well, either way, if we have that date, I just wanted to make sure that I think there were several things left out of the.
There was more than just this issue left out. I just don't remember offhand what else.
Me either. It's been a while.
Your Honor, sorry if I may, I think a lot of them were connected to this issue of the final amount of the child support. My proposed final judgment had been to reduce the child support payment to pay off the equalizer payment. But because we can't calculate child support because of this outstanding transportation expense issue, that can't be resolved. My position is that once this issue is resolved, the remaining issues were argued at trial and were fully in front of Your Honor, and perhaps additional proposed final judgments from myself and Ms. Talrico based on what was presented at trial, I think should be sufficient without requiring the need for any further court time.
Okay. Well, why don't we proceed on today's motion, then we can talk about the 30th, but either way, we can keep that date available to the extent anything else needs to be done in this case.
Okay. Thank
right.
you. Judge, and I do think that my motion is pretty simple and self-explanatory. Evidence of travel expenses was inadvertently left out of evidence during trial by both parties. I mean, I'm sure the father's position is that it's unnecessary. It certainly seems like that from the memorandum in opposition. But I do think that this information is material and necessary. The court does have the discretion to order an offset for child support costs for the parent having to pay costs when it comes to travel expenses. And I believe that the case I cited, which is Miller v. Miller, also cited by the father, is the case that does talk about how travel expenses should be considered by the court. And in that case, I'm pretty sure that that case also used travel expenses to offset the amount of child support. The evidence before the court during trial was that the father was indigent. So the reality is, Judge, that Ms. McKee will be paying all of the travel expenses. That is the reality according to the evidence before the court. She should get a credit for that. Frankly, she should get a credit after the child support guidelines are calculated, because she will be paying both her expenses and Mr. McKee's expenses. This was information that we did have with us. Again, it was an oversight and inadvertently left out with regards to my questioning of Ms. McKee. None of it will be speculative if you do allow this. The evidence before the court is that she has taken this trip numerous times with the children throughout their life. And it is something really simple and at her disposal to, come up with what kind of costs she will be incurring, not just airplane costs, but travel costs for an entire year. That is possible to gather and provide to the court with accuracy and not speculation. It is Ms. McKee's intent to exercise every date given to her. The cost will be significant. It's common knowledge that minors do have to travel with a person, an adult, and there's a fee for that as well. So there's lots of evidence that I think the court should hear so that child support is calculated in equity, Judge. We just want what is fair and what the reality of the two parties, what their financial situation is at this time. I think it would be unjust to continue without it, given Mr. McKee's financial circumstances. But if the court does decide not to allow us to present evidence of travel, we would ask in the alternative, or at the very least, that Mr. McKee be responsible for every single return ticket on his own, if that's what is going to happen, to ensure that Ms. McKee can, afford what is necessary to make sure that she exercises all of the time given by the court and has a continuous and consistent relationship with the children, and can exercise every amount of time that the court has given to her. I don't really have any other argument. I think the Miller case is straightforward. The father's opposition, again, relies on speculation. I don't believe that any of the testimony that will be provided to the court will be speculation. These things are easily able to be calculated with accuracy. Plus, you have Ms. McKee's, testimony of what she has paid in the past. She did make these trips with the children several times throughout their life, so she can testify to that. And the information is necessary to do equity.
Okay. Thank you, Ms. Talrico. Ms. Cohn?
Thank you, Your Honor. And it's the father's position, obviously, that the court should consider transportation expenses when it determines the child support, that the court needs to determine how those are going to be paid. I believe that the case law is very consistent in that the court generally requires the parties pay for transportation expenses according to the financial responsibility identified by the child support guidelines. In the majority of the cases, or at least all of the cases really besides Miller that I was able to find, there was never a discussion as to putting the travel expenses in the guidelines. They were always ordered to be paid outside of the guidelines pursuant to the percentages of financial responsibility of the parties. As I stated in my opposition, I think that this is the most reasonable way to address the transportation expenses, because it will actually make sure that the transportation expenses expended by the parties is what's being paid, and that nobody is getting a windfall for either the trips that were, contemplated to be taken but were not taken because things come up and these are teenagers and they have activities and they have things. Perhaps not all these trips that Ms. McKee has planned are going to be taken, and or that more trips aren't taken, or that the flights end up being more expensive than the court determines they will be at a hearing that we have. I believe that the way that the statute is organized and that the case law dictates the most equitable way to deal with it is to say whatever the expenses happen to be, the parties need to address those as they come up. Not some, in the future, we anticipate that a flight in Christmas of 2023 is going to be the same as the flight at Christmas 2021. Or the flight for the summer is going to be the same this summer as it is 2 summers from now. And again, the parenting plan that the court ordered has 6 optional weekends for the mother to take. In and of itself, to me right there, it states that we don't know how many trips are going to be taken by the kids up back and forth to Connecticut throughout the year when there's this option of 6 additional trips. And I believe the testimony from trial was that Ms. McKee's income is not going to be so significant that she can even afford her portion of all of those trips. And to the extent that the mother is arguing that there's no possible way that the father can pay his fair share of these expenses and that he's never going to pay them, again, it's just completely, it is speculative, right? The father has a limited income. but he manages those expenses. If he is required by a court order to pay his share of the expenses, he will pay those expenses. If some reason he fails to do so, there are remedies that the mother can exercise to get the cost. But to think that that is a foregone conclusion, that that is going to happen, is I don't believe the court can draw that conclusion and make any basis for a ruling on how the transportation expenses are incorporated on that very speculative basis, or for that reason. So, Your Honor, we would ask that the court order the travel expenses to be paid pursuant to the child support guidelines percentages. I believe it's about a 65-35 based on the child support guidelines I had submitted, and they be paid in that fashion.
Okay. Ms. Talrico, rebuttal.
Judge, I believe that it's the Miller case that also indicates that, yes, this is how it is done, or the cases, do, as Ms. Khan says, say that this is how they should be paid according to the financial responsibility. But the Miller case, I believe, also says that the court has discretion to go away from that, for good reason. And I do believe that given the party's financial situation, the fact that you haven't heard what the expenses are going to be, when you do hear that what the expenses will be, I think you will have good reason to deviate from what the the general holding has been. It is entirely in your discretion, Judge, when it comes to this type of expense and how it is that you wish to order the parties pay it, to make it a just outcome.
Okay, Ms. Talrico, why isn't that we can't do it? And I'm not saying what the percentage would be. Why is it your position that we wouldn't allocate it just based on a percentage rather than actually hear evidence on amount and things like that? Because it seems to me that costs like airfare, they're not static costs. I mean, they're not fixed. It's something that can change based on the time of year, the time of day, what flights happen. It doesn't seem like we can treat it as if it's a fixed cost. So what's the objection to doing it the way that Ms. Cohn is doing it, and instead of taking any evidence, simply doing it based on an allocation?
That based on the evidence before the court, the father's allocation looks nearly impossible for him to cover, and I'm concerned that once it comes the time to buy airline tickets, that this will be the holdup, and she'll never have them with her. And by the time you get a motion for contempt heard, because it isn't an emergency, the summer's gone. I just foresee a lot of litigation, and I also do feel that. And that was a request made at trial, that she be given a credit for the financial burden that this is going to be on her. Ms. Khan brings up one of them getting a windfall. I think based on the evidence before the court, the mother will be stuck with these plane tickets several times a year and unaccompanied minor fees, and a large amount of child support on top of that. And I just foresee us being here, and that's really what I'm trying to avoid.
If the court was going to go by percentage rather than hear evidence, and let's be honest, any evidence of what she's paid in the past is going to be outdated, what would be the suggested percentage you would be requesting?
I would request
Ms. Cohen's requesting according to the child support guidelines, whatever they come out to be.
I think that based on the evidence before you, because the mother is the only person who's gainfully employed, the court probably should attribute those costs to her and zero out child support, or give her that annual cost or those costs to offset the the child support, which is another reason why I thought the numbers were necessary. In the alternative, I guess the most fair would be 50-50.
Okay. All right. Give me a couple minutes. I want to refresh myself on the case law, and I'll be back.
Your Honor, sorry.
Yeah.
Can I just respond to that last,
Sure.
Ms. Talrico's proposal of 50-50? I cite to a case in my opposition, Chris versus Chris, 854 Southern 2nd 244 from the first DCA, which states that the general rule, such as expenses other than child rearing expenses, should be allocated between the parties in the same guidelines ratio as governed allocation of other child care expenses, unless the trial court makes findings explaining why a different allocation is needed to achieve an equitable result. So again, I believe the case law is pretty clear that the default is what's in the child support guidelines, financial responsibility. And again, in this case, in light of the fact of my client's very low income, his disability that prevents him from an increased income, that Ms. McKee is choosing to move to Connecticut, that needs to be considered. It's her choice to relocate. And I just believe that Your Honor, the allocation of my child support guidelines is 67% for mother and 33% for father. I believe that based on their incomes would be a reasonable and equitable distribution of the expenses.
You said it's under your allocation of 67% for mother?
Yes, it's actually 66.51% for mother. So
okay.
33.49.
Okay. All right. Thank you both very much. I'll endeavor to be back in about 10 minutes.
Okay. Thank you, Your Honor. Mr. McKee, just mute yourself for these 10 minutes, okay?
Yeah, let's see. I ain't got nothing on my screen yet. To mute. Let's see.
Or if you can't mute yourself, just be cognizant that you're not on mute.
You can't hear me now, right?
No, we can hear you. I can hear you.
You can still hear me?
Yeah.
I got the mute thing. Let's see.
Thank you all very much for your patience. Ms. Cohn, I'm going to ask you to prepare the order. I am going to be denying the motion to reopen testimony in evidence here today. And the reason I'm going to be doing that is I just don't see travel costs in the evidence that would be offered as it relates to them as very important to the court's decision on this particular matter. Anything that would be shown as to what the mother did before with her travel is by its very nature going to be out of date. There's no such thing as fixed travel costs. And the court is going to decline to make something fixed, which by its very nature is not. Airline tickets change prices all the time. New routes come up. And so it's just not going to be the same depending on the time of year or how they decide to travel. So at this point in time, I'm not going to reopen the evidence. I just don't feel like there is a need. The court did review the case law that was submitted by Ms. Cohn. And as it relates to the specific case that was important was the Christ case that says, as a general rule, such expenses like other child-rearing expenses should be allocated between the parties in the same guidelines ratio as a governed allocation of other child care expenses. God, I said that terribly. The general rule that such expenses like other child-rearing expenses should be allocated between the parties in the same guidelines ratio as governed by the allocation of other child care expenses, unless the trial court makes findings explaining why different allocation is needed to achieve an equitable result. I am going to find that a slightly different allocation than what's included in the current child support guidelines proposed by Ms. Cohn is required to achieve an equitable result. And here are some of the reasons for that and the findings as to why a different ratio is needed. First, there is a concern, and I know it is speculative at this point, but just based on the financials, a major concern that the father will be able to contribute at all to the expenses. Secondly, there is another issue, is that he's not able to supervise any of this travel or really be a part of it due to his physical condition. In addition, we do need this travel to happen simply because this is such a drastic reduction in the mother's time with these children upon her relocation to Connecticut. And finally, her financial situation, as we delve deeply into her finances during the course of the trial, is unlikely to greatly improve as a result from the move to Connecticut. In fact, if it improves, it'll be barely. For all of those reasons, I do find that a slightly different allocation is required to achieve an equitable result. However, I don't think a 50-50 allocation is reasonable because there are a number of visits that are her option and therefore would be out of his control. I do want to make sure that there's some good price shopping going on as it relates to this travel and when it comes to the tickets. And I do think she needs to have more skin in the game than he does. For all of those reasons, the order will allocate travel responsibility as 55% for the mother and 45% for the father. Ms. Cohn, do you have any questions as it relates to the court's order?
No, Your Honor.
Okay. Ms. Talrico, do you have any questions as it relates to the court's order?
No, Judge, so I'm assuming that the child support guidelines will be as they are according to the incomes that you provided at 75 overnights.
Yes, I assume based on the way this is normally done, it would be just separate. It would be a separate thing in the final judgment relating to the travel expenses allocation. Okay. All right. Best wishes to the entire family going forward.
And sorry, Your Honor, just would you like us to submit like another final judgment? Because again, like we talked about at the beginning, there's some other issues of the payment of the equalizer payment. How do you want to resolve those? Or would we resolve those with this order?
I was hoping that they would be resolved by this order, but the only thing that was on my schedule to be heard today was this. So I can't make any resolutions on anything that's contested. I'm hoping that with this order that maybe it resolves the other issues. And if not, we have the date set for June 30th, but I'm hoping that it's not necessary.
Because, Your Honor, like I said in the beginning, I believe now that we have this decision that Ms. Talarico and I can submit proposals as to those few related issues that were left out of the final judgment. I guess I'm just wondering the form in which we submit those proposals.
I liked it how you did it before with you submitting the final judgment, Ms. Talarico submitting the red line. Based on that, I may not need to hear anything on the June 30th hearing, I might be able to make the final decision right then and there. I guess I was grappling with whether or not you have to rewrite a whole final, or not rewrite it, but do the whole final judgment, or just have this next part as to the parts that were left out, although it may not be as clean.
Right, and I have the Word version of, and I can make sure that it's the same as what your Honor entered, and submit it as maybe an amended final judgment or a supplement.
That's
an amended.
That's probably, because it's not really amending it, because there's nothing changing it. I had reserved. I think technically I would prefer this to be a supplemental final judgment, although I'm just worried that that's going to confuse things in the future.
Your Honor, if we had a final judgment as to the issues reserved, something along those lines as the title, and then just do a separate one addressing those issues?
That sounds perfect, because then we don't have to read through a giant filing to do what I think, if I recall correctly, is only like 3 or 4 issues.
I like that. The final judgment on issues reserved, I think, would be the cleanest way.
Okay.
Yeah.
And then, sorry, just so I'm clear, but you'd still like an order denying this motion with those findings, and then the final judgment on the issues reserved, kind of restating these plus the other issues that were not addressed due to these outstanding issues.
So here's what I think we can do. You can just do a short order denying the motion to reopen evidence, because that one's clear. And in the final judgment, when we talk about how I allocated trial expenses, just brief about what my findings were to deviate from the child guidelines, because that doesn't need to be in the order denying it. The order denying the motion to open could just be because the court denies it because it doesn't find that the travel expenses here could be proven as a static cost anyway.
Okay, understood. Thank you, Your Honor.